Thank you, Mr. Chairman. I'd like to thank you and Ranking Member Velasquez, Mr. Evans, members of the committee for this opportunity to be here today. It's an honor to participate in this important hearing focused on the role of intellectual property in supporting small business development and growth. I'm here on behalf of the Alliance for U.S. Startups and Inventors for Jobs. USIJ is a coalition of over 30 startup companies and their affiliated executives, inventors, investors that depend on reliable patent protection as a foundation for their business. It's difficult and perilous to start a new company from scratch. For companies built around a new invention or committed to solving a complex problem, it also requires investors with a very strong appetite for risk. The U.S. patent system is designed to incentivize and reward this risk. Unfortunately, over the past 15 years, we have seen the foundations of the U.S. patent system eroded by court decisions and changes in U.S. law. This has resulted in the U.S. falling from number 1 to number 12 in terms of IP strength, according to the U.S. Chamber. We believe there's a very strong correlation between the patent system and the willingness of entrepreneurs and investors to take risks on big breakthroughs and complex problems. USIJ is releasing today the results of a study we conducted on the trends in venture capital investment from 2004 to 2017, which I've included in my testimony. I will touch on a few of the key conclusions and offer some recommendations on how Congress and the administration and PTO can strengthen the U.S. patent system to better support startups in key tech sectors. To be clear, not all small businesses and startups depend on patents for their success. Many do not, and some even find patents a burden. But companies that invest heavily in R&D to create breakthroughs in strategically critical technologies do depend on patents to protect them from predatory behavior of would-be competitors anxious to copy any new product or technology once it is proven workable. As the U.S. patent system has slipped from the strongest in the world to number 12, we have seen the elimination of injunctive relief for patent owners, significant limitations on the ability of inventors to even obtain patents in key areas of life sciences and software, and a procedure at the U.S. Patent and Trademark Office that allows an open-ended opportunity for anyone to challenge any valid U.S. patent multiple times and often without any business reason for doing so. So how is the market reacting to all of this? As you might expect in some ways. Even though total venture capital in the United States has increased nearly fourfold over the last 15 years, the portion committed to small businesses in important technology sectors has declined significantly. In 2004, 21% of all venture capital funding in the United States went to the following strategic patent-intensive sectors: internet networking, wireless communications, semiconductors, drug discovery, and medical devices. In 2017, only 3.2% of venture capital funding in the U.S. went to these sectors. So who are the beneficiaries of this relative decline in funding for strategically critical technology? In 2004, 11% of all venture capital in the United States went to the following sectors: social network platforms, business-to-consumer technologies, financial services, and software apps. By 2017, 33%, one-third, of all venture capital in the United States went to these sectors. While the latter group has certainly led to some interesting products and services, created a lot of jobs, and led to some very well-known and ubiquitous global companies, these are not typically the sectors that are generally investing heavily to push the outer boundaries of science and technology to remain competitive in a global market. These declines are fairly shocking unless one believes that the U.S. can maintain its technological leadership with minimal investment in startups that are working in the areas of new drug discovery, networking equipment, cybersecurity, AI, medical devices, biotech, semiconductors, computer hardware, and a host of other core industrial sectors, while one-third of the funding for new companies in the United States goes to apps, social media, and online shopping and banking platforms. The good news is that there are some specific things Congress and the U.S. PTO can do immediately to revitalize the U.S. patent system for inventive small businesses. These include passage of the Stronger Patents Act. I'd like to thank Ranking Member Velasquez and Mr. Norman for co-sponsoring that piece of legislation. Providing statutory clarity for patentability of life sciences and software inventions under Section 101 of the Patent Act. In addition, PTO can make some needed reforms to change its post-grant review procedures. We strongly support the pending rule change to discontinue use of the BRI standard for claim construction, Patent owners should be allowed reasonable opportunity to amend their claims during a post-grant review proceeding, and USPTO should address serial attacks on patents held by small companies by larger competitors working in collaboration and with surrogates. This has become a major problem for technology startups. Mr. Chairman, I appreciate the opportunity to participate in this hearing and look forward to all the questions.